Okay, this is Dr. Herskowitz again for the last half of Chapter 4, talking about the trial itself. We ended talking about the statute of limitations. I just want to make sure that you understand that in a civil case, actually in criminal cases as well, there comes a time period after which if the plaintiff does not bring an action, it's barred. The court will not allow to hear it. For contracts, it tends to be 2-3 years after the contract's been signed. That just means that you can't come back after 20 or 30 years and start bringing up lawsuits. So statute of limitations, if that's exceeded, that absolutely bars the plaintiff from bringing an action. So that's one of the pretrial motions would be if the defendants realized that had passed. Okay, now we're going to talk about the trial steps, the steps in the trial. The first thing that goes on in the trial is the attorneys get together in front of the judge and they do what's called voir dire. Voir dire is actually selecting the jury. Each attorney has so many peremptory challenges out of a pool of people. They come up. The pool sits in the jury box. They come up one at a time, and each attorney will ask questions. And each attorney has right 3, 4, 5. I'm not sure what the number is, but they can just say, "I don't want this person." They can also dismiss a potential juror for cause. For example, if a person in the jury box is a nurse, and the case is dealing with medical issues or with nurses, that would be a natural conflict, not a conflict of interest, but a bias, and so they can discharge that person for cause. But the preemptory ones, they have the right to dismiss so long as it's not for a illegal purpose. You cannot dismiss a person because she is a woman or because she is black or he is black. So you can't apply racial conditions, but if you just have the feeling that that person is not going to be good for your client, you have the right to disallow that person to be sitting on the jury. So you go through the jury selection with the voir dire. The jury gets set. The trial starts. Each attorney gives an opening statement. This is an overview. They tell the jury what they're going to prove. They're going to tell why their client is not guilty or why the defendant is guilty. And it has no evidentiary purpose. It just lets the jury know how the case should be laid out. Then the presentation of the evidence comes down in the trial in front of the jury. And then when the parties get ready, each side rests its case. One side or the other may ask for a directed verdict. They're going to be saying to the judge, as a matter of law, they haven't proved their case at all, and therefore ask you to direct the verdict. Once in a while that happens. Usually it does not. The jury is a system that is very sacrosanct in the U.S. They then give their closing arguments. They explain why their case, why their client is guilty or not guilty, should win or should not. Instructions are given to the jury by the judge. Now this is a very key part because both attorneys will be arguing as to what types of instructions should be given to the jury. And so the judge will listen to both of them, get maybe written submissions, and then the judge decides on what the instructions will be to the jury. The jury then deliberates and comes up with in most states, a unanimous decision, and that gives the jury verdict. So we talked about voir dire, speaking the truth, dismissal of prospective jurors for cause, peremptory challenge. I talked about all that. And so Supreme Court outlawed racial discrimination and peremptory challenges. Here's the actual case that follows up with what I had said previously. Directed verdict refers to the power of a court to grant a decision in favor of defendant when insufficient evidence is presented at trial. Okay, the burden of proof. Criminal cases beyond a reasonable doubt. In civil cases, it's the preponderance of the evidence or clear and convincing proof. And this comes out as part of the jury instructions that the judge gives to the jury. Deciding the case, the principal job of the jury is to determine the facts of the case. One party will say this happened, the other party will say something else happened. The jury is to look at all the evidence, listen to the witnesses, and come up with a decision as to who is telling the truth and who is not. The decision of the jury is announced in the courtroom when the jury deliberations are over. And they do not have to give any explanation or justification. They just give their actual verdict. The judge then decides whether to accept the verdict or not. 95% of the cases or more they do. Then the case is ruled finished. At that point, the litigating parties can file an appeal if they think that the judge has either allowed evidence in that shouldn't have been or had some other legal impropriety in the case. The appellate procedures, courts of appeal deal with the records of the proceedings in the lower case. They look at what the evidence was, what the jury decided, but they are not to determine the facts of the case, only if the law was applied correctly. Courts of appeal studies the issues, testimony, etc., and they come to a decision. The legal brief is a short description of the case by each party in the trial that's given to the judges. The enforcement of judgment decrees, execution when the case is finally over, the time for appeal is finished, the appeals have been finished, the retrials have been finished, everything like that. Then a court official can seize property of the debtor to be able to sell at public auction and then turn those monies over to the winning creditor. Garnishment involves having a portion of the debtor's wages paid to the court, which in turn pays it to the creditor, to the prevailing party in the case. So garnishment is taking a portion of the wages that the person has. Anybody can sue. Somebody says, oh, can you sue for that? Yeah, anybody, you can sue. The question is whether you can collect. And so you may win a Pyrrhic victory. If you go charging off, spend a lot of time, money, and energy, you win the case, but they're what's called judgment proof, and there's no money available to pay it. It's been a fool's errand. Time for appeal is expired. The case is finished. It's then called res judicata. And this determines by a competent court cannot be litigated by the parties again anywhere else. Do not get confused that because of res judicata that you cannot have two very similar cases, one in state court and one in federal court. Those are two separate crimes. You may be relying on the same evidence, and those would be two separate trials, and one could be done and the other one could then be followed up on. But res judicata says that in the judicial system you cannot have a case, you cannot just continue relitigating it until you finally get a jury that agrees with you. That's pretty much it for the trial. I hope that helps you, these parts A and B. You should be ready to take the quiz and do very well on it. Thank you very much.